Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. Today is June 20th, 2024. This is our Thursday phone call for the community. One Thursday it is on LinkedIn audio. Today, Thursday, it is on our conference bridge for the firm. I'll first go over the questions that I've marked as frequently asked questions in the posted questions. People post questions in our forums, forums.immigration.com. And then I'll answer the regular questions. And after that, we'll be able to take new questions. Somewhere along the line, I will lock the conference because I want to make sure everybody who's here gets their questions answered. Okay. So each time I answer a posted question, I'll invite from you folks, anybody has a follow-up question, please ask me a follow-up question. If you have one, do not ask me new questions at that time. For new questions, we'll first finish the posted questions, then start the new ones. Okay, right now I don't need to close the conference. Maybe another couple of minutes, I'll close it. Let me start with the first question I have marked as frequently asked question. And this call is being recorded, and this will be put out in social media. You can read it or listen to it. It will be on our YouTube as well as LinkedIn, Twitter, Facebook, all these accounts. So the first question I have posted, I have designated as a frequently asked question is, I'm moving to India in 2025 on H-1B extension. I-140 portability is an issue, and what is the future of my US opportunities? So the detailed question is, I need to relocate to India for family reasons in 2025. My I-140 has been approved for over 180 days. So what is the significance of that? If your I-140 gets approved, right away you inherit the priority date. So unless that I-140 is revoked for fraud or misrepresentation, that date is yours to keep. Okay. However, if the I-140 stays approved for 180 days, not only do you keep your priority date, you also keep your right to extend your H-1B beyond 6 years with any employer. And your spouse, wife or husband, if they are on H-4, they have the right to keep extending their or getting and extending their H-4 EAD. And this is true even if the old employer revokes the I-140 after 180 days. So that's why the 180-day period is critical. So the question now is, I'm going to India, I-140 is approved 180 days. I want to keep my options open. Is there any difference in moving to India before or after filing my H-1B extension? If I plan to return to the US with the same or different employer, there is no difference. In your case, because your I-140 is already approved and stayed approved for 180 days. So you have pretty much a forever right to keep extending your H-1B beyond 6 years whenever you come back. Is there a time limit within which I must return to the US with the same or different employer? This is a little difficult to answer because there are a couple of variables. Definitely about 6 years, there is no issue. It may be more. Do I need to go through the H-1B lottery again? Nope, not at least for 6 years. Does it matter if my priority date is current when I return to the US? Yes, that can be a problem. Because you keep getting H-1B extensions based upon your green card / I-140 only as long as the dates are not current. Once the dates become current, you have to explain to the government why you have not filed your 485 or last step of the process. Folks, there are enough people here. I'm going to lock the conference. Give me 1 second.
The conference is now locked.
Okay, so that was the first frequently asked question. Is there any time limit? No. Do I need to go through the H-1B lottery again? Nope, not anytime soon. Does it matter if my date is current? That answers all the questions under this particular entry. Does anybody have a follow-up question? No new questions. Do you have a follow-up question on this? Press *5 on your phone. Press *5. All right, so no follow-up questions. There is one. Let's see, area code 832 from Texas. All right, Texas, go ahead, I can hear you.
Hi, Rajiv. How are you?
Good. Tell me, what's up?
Okay, so actually, I got my H1 in April 2022 while I was outside of US.
Mm-hmm.
But also when I got it, I went to stamping as well. But once I got the stamping, my current employer, who I'm still working with, they offered me a job. So I moved to India, but I didn't pick up the US employer's job. So what happened is after a year, they revoked my H1. So I'm still in India now, but if I want to go back, how does it work now? That is the case.
Okay, so did I hear you say that you never joined that employer? The one who sponsored the H-1B?
Yes, yes, sir. I did join the employer, but I got the H1 picked up in lottery and got the visa stamp while I was outside the
Yeah, there is a case exactly like yours in which the USCIS said you no longer have an H-1B, you are back in the lottery. Okay. So, a couple of things I want to point out. What the government says and what the government does are often two different things because we have received many approvals in these situations, especially where the visa was already approved. However, in 2023, there was an appeal case where the government took a different position and they said, well, we are putting this H-1B back, or we would have put this H-1B back in the lottery, and we don't believe that you are exempt from the lottery because you never joined the employer. Okay. Now, this decision was never adopted by the USCIS as standard policy. So, to cut the long story short, there is some gray areas there. We don't know exactly how it's going to play out, but you should certainly try. No harm. Okay?
Okay.
Anything else?
Okay, thank you.
You're welcome. Good luck. Next frequently asked question. Extending parent stay in the US beyond 6 months on a B2 visa. Mother is here. I'm an IT pro on L1. My family is also here. My younger sister is also settled here. Father passed away. Mother is 60 plus. No other family members in India to stay with her. So is there anything long term? So the answer is yes. There is actually a prescribed usage for extension of B2 where you have a situation like this. Okay. And I've done it for up to 5 years for parents. I could have probably done more. It was a kind of an exemption made to cover those situations where the relationship is very close and the only reason they are not able to get an L2 or an H4 is because it's not your spouse or child. So the government said, you know what, we'll create an exemption. And they actually started this because in many countries there were common law husband and wife, or husband and wife for wife, same-sex couples as well. So government said in these cases, even if they are not entitled to an H4, we'll give them extended B2s. So it is possible. Okay, that might be something worth trying. *5. If you have a follow-up question, press *5. That's from New Jersey. New Jersey, go ahead, please. I can hear you.
Hey, hi, Rajiv. This is Manav. So in this case, can this subscription that you mentioned you did for 5 years, so is this a one-time thing or it has to be done, like if the subscription is given, let's say, extension of 6 months or 1 year, so after that period of time, it has to be done every time, or is there a possibility that the government provides this for a longer term, like say for the duration of the L1 visa, whatever is there?
Okay, here is where the discrepancy comes in. This particular exemption is State Department policy, but not Department of Homeland Security policy. Okay, so when you are inside the USA, you are governed by Department of Homeland Security, which acts through USCIS. When you are outside the US, you are governed by the State Department, which acts through the consulates. Okay. However, technically the government should give you yearly extensions. That should be the stated policy. But they usually don't. They make you come back every 6 months. And you keep applying every 6 months. We have clients who like us to apply every 6 months. I have told them, I'm telling you, I think it's a waste of money. Get the paperwork prepared first time from a lawyer. After that, you can use the same paperwork because the basic premise is the same. I am here. Mom is alone. I can't send her back. I want to take care of her myself. She's not going to break the law. She's not going to do anything illegal. I am not going to do anything illegal. I think that's a good premise. And it's the same premise that remains. Now, there may be some legal arguments you can make and your lawyer should be able to make. There is something called Foreign Affairs Manual, which is a State Department standard operating procedures. Volume 9 of Foreign Affairs Manual is about visas. And if you do a search for cohabiting partners, because that's where it started, and just do search for cohabiting partners, Foreign Affairs Manual, you'll come to the exact provision under B1, B2 of 9 Foreign Affairs Manual. Okay. You'll be able to read up about it, but it's the same thing what I told you right now. So it is possible. Do you have any other questions?
Okay. Yeah, just one more follow-up question. So is this something which should be done once, like my mother is here, or it should be done while she is in India?
There is no provision. There's no provision to do it while she's in India.
Okay, so she has to be here and then it can be attempted.
Mm-hmm. Absolutely.
Okay,
All
understood. Right. Thanks for the
You're welcome. You're welcome. Good luck. That's one of the most difficult things we do as people who have migrated, because parents, it's very difficult to then take care of parents from remotely. I mean, it's not possible. Unfortunately, Zoom doesn't do that. So I can relate to that. And I think the government is quite sympathetic with most of these cases. Okay?
Yeah, exactly.
Good luck. All right, let's go on to the next frequently asked question. This one is B2 to F1 visa, work authorization, visa stamping, and optimal strategy for a laid off H-1B professional. I'm on H-1B, got laid off, switched to B2, and B2 is about to expire. I can request an extension of the B2, but I want to enroll in a master's or a PhD program. Once I switch to an F1, will I be allowed to work on H-1B? Absolutely. You can convert back to H-1B. Can I also continue my course? The answer is yes. So think about it. What is F1? Student visa requires that you must maintain a full course load. H-1B says you have to work and you can also simultaneously go to school. And because you are not on F1, you can take less than a full course load. So if you decide to do 3 credits or 6 credits a semester, that's perfectly fine. Okay. When the F1 is approved, will I have to leave the US to get visa stamped and re-enter? And the answer is no. If you are still in status when you apply for B2 to F1 conversion, you can get it within the United States and you don't have to get a visa until you travel outside the US. Should I extend my B2 or should I switch to an F1? The way I have told people to do this is simply this. I've said, look, if you think you can find a job in the next 6 months, stay on the B1, B2. But if you think that's dicey or unknown, I would rather have you spend your time studying, getting more education, and also get curricular practical training if possible. Okay? So that's pretty much it. Star 5. If you have a follow-up question on this, press star 5. All right. This one was, oh no, there is a question. Area code 320. Minnesota. Minnesota, go ahead. I can hear you. Minnesota.
Hi, Rajiv.
Hello.
Can you hear me?
I can hear you. Yep.
Hello.
Hello, ma'am.
Thank you for taking this call, Rajiv. Actually, I'm in the same situation right now.
Ji.
And I have applied for the master program, and my I-20, my program has been approved, and I'll get my I-20 maybe next week.
Mm-hmm.
So, like, my question is, my B1, B2 is ending by next month.
Mm-hmm.
Do I have to? And my classes start in August, so there is like a time gap in between.
You should be okay.
If I apply
Yeah,
for
you,
F1,
you should be okay. You should be okay. If you go to the USCIS website, somewhere there they have a policy statement which said we are changing our policy. Previously it used to be that you must have B1, B2 going all the way to within 30 days of your F1. But now they are saying that as long as you file it when you are in status, you should be able to remain in the US and convert to F1 automatically. Double check that. The school can also tell you that. I'm pretty sure you're going to be fine. Okay.
Oh, okay. So, yeah, another question was related with school. Like, do I have to inform, like, my DSO about change of status, or
You should.
once I convert, it should be fine?
No, you should let them know. Because in order for them to issue the I-20, they might want to ask you about your current status, etc. So, best to let them know. Why not? We're not hiding anything.
So, yeah, sure. Can I apply F1 myself, or does the university does it for me?
University will give you
For
an
the status
I-20.
change.
They might give you a pamphlet on how to do it. It's really not rocket science. You can read the instructions on the form carefully. Check with your DSO if you have any questions. You have any questions other than just filling out the forms, something doesn't make sense, come talk to me. We are here every Thursday anyway. Okay?
Oh, okay. Yeah. Thank you so much, Rajiv. That's all I have for today.
You're welcome. Good luck. Okay, next frequently asked question. Do we have any more? We just have regular questions, I think. Yeah, let's go into the regular questions. Now, folks, I'm going to answer all the posted questions and the follow-ups to the posted questions. And because I've locked the conference, I'll make sure that I answer everybody's questions who's here. Okay? So let's start with the regular questions. This is, which question number is this? Question number 4. H-1B stamping and passport renewal to maximize I-94 validity for upcoming India trip. Got my H-1B approved, currently in cap. Need to travel to India in December for stamping. My passport expires in 25. That gives me very limited I-94. Should I fill the DS-160 with the current passport, renew the passport, and then when I go for the interview, bring the new and the old passport? That works. Why not? Option number 2, get the current passport stamped, and then whenever the new passport comes, keep them both together. That also should work, but I like the first option better. That you fill out the DS-160 with the current passport, renew passport, take the 2 passports with you. Okay? Let the consulate decide what works best, but at least you would have told them ahead of time, during the visa stamping, this is what your situation is. So I like that option a little better, which is get your passport renewed and take it with you. Star 5. If you have a follow-up question, press star 5. Next question. Visa options for long-term US employment, H-1B, F1, L1, and specialized visa for AI/ML hardware professional. So I saw that you have not been able to get selected. Third time H-1B not picked up. STEM OPT is ending in Feb of next year. So you won't get, of course, you can always keep applying for H-1B even if you're in another status or you are outside the US. Goal is to have future long-term stay employment. Option 1, day 1 CPT. Already on master's STEM OPT. Am I even eligible for another master's? You are. Or do I need to go for a PhD? You can, but you don't have to. It looks like you're more focused on hardware. You could always enhance your skills either in some kind of a technology management area, like an MBA technology management, or you could, if you want to go into something more specific like robotics or control systems, you could look around for degrees that teach you that area. So I think that's definitely possible. You could do multiple masters. How predictable is trying to get new F1 visa on day one CPT? Pretty much predictable, but traveling is difficult to predict. Especially, we can never tell what the Customs and Border Protection does at the airport. Okay. Personally, I think it's perfectly legal. They should not give you a hassle, especially when you are merely enhancing your career. It's not like you are going from computer engineering into history or geography. So I think you should be okay, but it's difficult to predict travel. Getting OPT, first year OPT, we already know going in. Should I consider applying to Canada, come back to USA after 1 year? Yeah, that's a great option. If you can do an L1A, not L1B, how realistic and reliable? We've done this many times. Is there any major advantage of this strategy over day one CPT? Definitely, because you're opening your door to a green card, very quick green card. When I say very quick, it's compared to EB2, okay? Getting Canadian citizenship could be helpful because you get more visas. I like TN visa, but I like E1 and E2 visas even more. Why not transfer to India over Canada? No, you can go to India. So L1 requires that you have worked 1 year outside USA for the company. That's it. So can I apply for 4th H-1B lottery? EAD ends on 6th Feb to March, March to April. So you can apply for the lottery, but you won't have enough time to apply for the visa. So you will end up either changing to another status like B status or F1 status, or you will end up going to India, which is fine. And you can come back on H-1B if you win. You should look at O1 visas, whether they are a possibility. Normally they are not for most people because they require us to prove that you are one of the very top professionals. Now, I'll grant you this, that in O1, they are a little bit more charitable than they are in EB1A, although the criteria are the same. Okay. Certainly, you should have your resume looked at if there is an O1 possible. Press *5. If you have a follow-up question, press *5. Okay, so this one is from area code 774, which is Massachusetts. Yeah, Massachusetts, go ahead. I can hear you.
Yeah, hi. So, follow-up question is that only. So, for EB2 also, the more education we have, it does help, right, for the immigration and future?
See, when you say help, it could be marginal or it could be substantial help. It all depends upon the category and your circumstances. I told you generically speaking. Yeah, generally speaking, the more education you have, the better off you are, or the more qualifications, I should say. Have you chaired conferences? Have you written books or book chapters? Have you written articles? Have you performed critical role for distinguished organizations? These are EB1A criteria, but they also help in NIW, and they can tangentially also help in PERM-based EB2, EB3 cases. Okay.
Okay, sounds good. Thank you.
You're welcome. All right, so let's go to question number 7. The gap between F1 OPT and H4 status. What happens? Okay. Wife's OPT is expiring 30th June. We applied for change of status from F1 to H4. And we asked for duration starting July 1st. So OPT expired 30th June or expiring 30th June. Yeah, that sounds reasonable. Her 539 and 765 both got approved, but they are both valid from October 2nd. Why would they do? Oh, October 2nd. You had asked for July 1st. Okay. She technically does not have any status between July 1st to October. Is this allowed? Yeah, it happens all the time. So these are those practical problems that you will never understand until you get into immigration law. Is it going to be a problem? No. Not a problem. Can she stay in the country? Yes. Can she work under any circumstances? Probably not. Star 5. If you have a follow-up question, press star 5. Okay. Next question. This is a very important question, guys. When you do PERM. So PERM refiling, consequences of office closure and remote work on prevailing wages. My PERM was filed in May 23, but they recently closed the local office where I was based. My team and I have received an exception to work remotely. The company's immigration department says they'll need to refile the PERM. Okay, so you're trying to understand what the heck is this. We are also discussing the possibility of moving to a new office within 50 miles. Okay, yeah, definitely this is a very important to understand situation. The PERM-based, labor certification-based green card is based upon a particular job location. Okay, and what is that job location? That job location is within the same metro area or normal commuting distance. Normal commuting distance is normally considered to be 50 miles. We have won cases in New Jersey, New York with even 75 miles. But the closer you are to 50 or less, the better off you are. Okay. Now, normally when we process PERM-based cases, what we do is, let's say the company is headquartered in Minnesota. I will say that this is a consulting job which can be relocated, and therefore under the Department of Labor guidelines, I think they came out in I'm trying to remember, early 90s or late 80s. Those guidelines said when you have a consulting sort of a company, so-called roving employees, where the employee could be placed wherever the project is, you should consider the corporate headquarters to be the virtual office where the person is working. What does that do? What that does is no matter how many offices are opened or closed, because your job is located in the headquarters, Minnesota, it doesn't matter if the Florida office closed, doesn't matter if the California office closed, doesn't matter that you were working in Washington, D.C., and now you are moving to New Jersey. None of that matters because the job is located in the headquarters. That's how it should have been filed. That's how we file most of these cases. And most lawyers I know, they file it the same way. Okay. So the problem with you is because if they have said that the place of employment for the PERM is going to be where you are currently located, and then the office is closed, then you have a problem. Now, what if you moved within 50 miles yourself and they made it a home office situation? I think it's a little complicated. It can be done. I think it's perfectly legally possible. Or if they move the office to another location within 50 miles or normal commuting distance, that could work too. So what are my insights? My insights, if I have any, would be simply this, that your lawyer should explore the possibility of having you move within 50 miles, even if the office cannot be relocated. Would that involve, let me think about this, would you have to do the prevailing wage again? Probably not. But would you then have to advertise with that language, and that language would then become a problem for the earlier filed documents like job order or even the prevailing wage? That's the question your lawyer should research, if it is possible for just you to move. But if the office is moved within 50 miles, I don't see any problem. Your green card should be able to continue as usual. Star 5, if you have a follow-up question, press star 5. Question number 9. Portability and change of status options for H-1B petition approved via consular processing. My H-1B registration was selected in March 24. They filed H-1B through consular. I got my approval notice Would I be able to change employers solely with this document? And that's where we are uncertain. It's a gray area, but if you have no choice, do it. If I ensure that my current employer does not revoke my 797, would I be able to port my H-1B without any H-1B stamp? Now, remember one thing. In most cases, even though technically this H-1B was never triggered, but if an H-1B is triggered, the employer is required by law to revoke your H-1B. They don't have a choice in the matter. Okay. In your situation, can they choose not to revoke? Yes, that will be nice. But these are all, like I said, gray areas of the law. If you listen to the beginning of this recording, you will hear me discuss this idea, what stage of H-1B transfer is advisable. Okay. Is it possible for my new employer to submit a new H-1B petition requesting a change of status? I think, again, gray area, who knows? If you have no other option, try it. With an I-797B approval, am I still counted in the H-1B cap? Yeah, that is where the problem is. Because I would have said, if you asked me last year, yeah, sure, you are out of the cap, no problem. But now it's become more uncertain. So we don't know how it's going to work out exactly. If you have to switch employers and you have no other choice, by all means do it. But don't hold your breath that this is going to work out. It may or may not. Star 5. If you have a follow-up question, press star 5. Question number 10. Level 1 wage impact on H-1B extension after 3 years. So, level 1 wage is appropriate where somebody is still very new to the job. They're still learning the job. Now the question is, does the wage impact my extension 3 years later? They cannot keep you at level 1 3 years later because now you have experience in the job. So I'm not sure exactly what you're asking. Press star 5 if you're here. Press star 5 on your phone. Okay. So they will not be able to do an extension for you. Because see, look at this. My employer filed for my H-1 LCA in 2022 on level wage. I think that's a problem. You cannot keep extending 2 years, maybe not, but 3 years or more of experience, they can't file level 1. Yeah, they won't be able to get an H-1B approval. Of course, USCIS could be asleep at the wheel and they don't notice this problem. But if they do notice it, I think your case will be denied. Press star 5 on your phone if you have a follow-up question on this. Star 5. Question number 11, and I think we have one more after this. Then we can start the new question. Question number 11 is optimizing H-1B spouse's PERM to H-4 EAD transition for continued employment. Hi Rajiv, I'm currently on non-profit H-1B. My spouse has just had his PERM approved. We expect his I-140 approved within the next 6 months. I plan to transition to an H-4 EAD and avoid the wait time for an H-4 EAD. I also read about choosing a future start date. Could you help me understand how that works? Yeah. So you cannot apply for an H-1B extension more than 6 months ahead of time. But there appears to be no such rule for H-4. Okay. Even though conventionally we keep it so that we don't ask for an extension on EAD more than 6 months ahead of time from the date when we file the case. So can you get it filed a year ahead of time? You can try, or you can call the USCIS customer service. They'll probably elevate you to a level 2 officer to explain to you what the law is. You can ask them. There's no written law on this issue. Okay, how far ahead can you apply for H-4 EAD? I would say 6 months is perfectly okay. I'm pretty sure that should work out fine. But more than that, that should be researched. Okay, So that's how it works. Star 5. If you have a follow-up question, press star 5. Last posted question. F1 status discrepancy. I-94 was not updated after the change of status. My friend transferred from B to F in 2016. Received the 797 approval, DS. I-94 never got updated. Wait. See, the I-94 that you get with the approval is the I-94 that matters. He never noticed it. Is this normal? So when the approval comes, at the bottom of the approval, the bottom fifth of the approval should be the I-94, and that should say DS. And that's the only I-94 that matters. Are you here? Press star 5 if you are in the call. Because a couple of things that I'm not sure. Do they not have a new I-94? They should. And that's the one that matters. Okay. Folks, anybody has any question, press star 5. We'll take new questions now. Anyone has any question, press star 5. So far I have 3 hands up. Anyone has any question, press star 5. Oh, that's easy. 3 questions. Let's start in the order. 4 questions. The order that you logged in. Let's say we gotta go to Texas first, area code 832. 832, where are you? Here you are. Texas, go ahead, I can hear you.
Good evening, Rajiv, sir.
Good evening, ma'am.
Sir, my I-140 appeal has been rejected on June 3rd, and my I-485 has been transferred to another department on June 11th. And my advance payroll is valid till July 19th, but I'm presently in India. I'll be back on June 24th. So what would be the scenario? When I come back, do I have to face any questions at the port of entry?
They probably won't let you in if they find out that your 485 or your I-140 was denied. Okay. So...
But my marriage...
sorry?
My marriage green card, I applied before coming, and on May 3rd, but I didn't receive a receipt or any response for my D-145, which is surprisingly, and I reached out to the log box. They said they'll let me know within 72 hours, but I haven't heard back from them either. But I have the postal receipt that says that it reached the log box on May 3rd.
Okay. So the answer still remains the same. If the I-140 is denied, you said you have an I-130 pending also? Ma'am?
Yes. Yes, sir.
Yeah, but did you request that the 485 be attached to? Was the priority date current for the I-130?
Yes, sir, it was current.
Are you married to a U.S. citizen or a green card holder?
U.S. citizen.
Oh, okay. So you should be able to return. So here's what you should do. You should have your husband contact the congressman's office. Okay. The situation is legally simple but procedurally complex because their procedures are not well defined. Contact the local congressman. Explain to them that she's married to a U.S. citizen. When she traveled, she had another case pending, which was later denied. But that 485 can now be attached to the I-130. Okay. They should be, USCIS should be able to do that. And if they do that, your travel back should be seamless, no problem at all. Even if you get the process started.
I think they already did that. That's what.
They already did.
Sorry.
Yeah, they already did that.
I think so, because a 485 has been transferred to another department on June 11th.
Yeah, but that does not necessarily mean anything. Because if it has been transferred to a local sub-office, that could be okay, but I still don't know exactly whether it was attached to the I-130 or not. So maybe you want to confirm that first. Okay. But I still think he should just contact the congressman. They'll take care of it for him. Doesn't have to pay anything, and they are much quicker than you trying to sort it out yourself. Okay?
Thank you.
You're
Thanks.
welcome.
Thank you so much.
You're welcome. Good luck. All right. So
Thank you.
you're welcome, ma'am. Next one is also Texas, area code 469. 469, I can hear you. Go ahead, please.
Hi, Rajiv.
Hello?
My question is, hello, can you hear me?
I can.
Yeah. So currently I'm on H-1B visa. I got laid off, so my 2 months period is going to end. And I was on H-4 EAD prior to this. So I have this H-4 EAD valid till next year.
Okay.
So how can I transition from this H-1B to H-4 EAD? Do I need to update again, reapply for the H-4 EAD again and wait for that 6 months period? Is there any smooth transition?
Yeah, I don't think there's a way out of this one, because when you change status from H4 to H1, you no longer had the EAD or the H4. Okay. Now, it's not a bad idea to confirm this with the USCIS also. Doesn't hurt. But if I were to bet, I would bet against you being able to keep the current EAD. I think you'll have to apply again. Okay.
Okay.
Anything else?
Okay.
Good luck.
No, I'm good.
Good luck.
Thank you.
You're welcome. Last two questions. Oh, I'm popular in Texas today. Another one from Texas. Let's see. This is area code 469. Where is 469? No, there's no. Oh, there is 469 here. 469, Texas. Go ahead, please.
Hello, Rajiv ji. Can you hear me?
I can hear you, sir. Go ahead.
So I have a similar question regarding to a previous question about portability of H-1B petition. So my H-1B was approved, my H-1B was picked in this year's lottery, and currently it is approved. So I have a question regarding the portability, and I am currently on cap extension, which has extended my current work authorization until September 30th. So my question is, I have got an offer from another big MNC, and I wanted to understand what is the process for if I want to switch or port my H-1B before it gets activated on October 1st.
Yeah, so I've answered this question today. Did you hear my answer today or no? Were you here?
No.
Okay. Yeah, I already answered this question. And in my mind, this is a gray area of the law. If you had asked me last year, I would have said that's not a problem. But this year, my answer must change. I don't know what the government is going to do. Because if you were, best case scenario, if you had already joined the employer after October 1st, and after a couple of pay periods you were changing, I don't see any problem. But in your situation, I have no idea how it's going to play out. We've done many cases like this, transfer successfully, but looking at what the government has been saying in the last 1 year, it's difficult to predict what they are going to do. My advice, try anyway and see what happens and how it plays out, but have a backup plan ready. Okay?
Okay, so the HR that I was talking to from the other employer, they told me that as long as my my F1 visa status is valid through October 1st, they would be I would be able to keep my H-1B approval status, and they would be able to
that's
file the change of status transfer.
That's, unless you misunderstood them, that is the most idiotic advice I've ever heard. One has nothing to do with the other. Okay? So that is just not true. And if it's just the HR people talking to you, just talk to their lawyers. Don't talk to the HR. All right?
Okay, I'll let them know about this.
Good luck.
Thank you.
Bye-bye. Let's go to Florida, area code 813. Florida, go ahead. You have a question for me?
Hi, Rajiv ji.
Hello, sir.
My question was that I was on F1, and this year my H-1B lottery has got picked,
Good.
and it has got approved.
Okay.
So my company wants to start the PERM processing. Do they need to wait till 1st October, or they can start right now?
They can start right now. No problem. Okay.
They can start right now. Okay. And about my wife, so she got H-4. So for her EAD, do I need to wait till the I-140 approval, or can
She
I do
can't-
it after 1st October? Or...
You can't get an EAD without the I-140.
Okay, so I need to wait for that.
Yep. All right.
And for my the last question is the OPT STEM EAD card which I had applied. I don't need that. It still shows that it's 4 weeks until it gets approved. But I would just not need it now, right?
No, you
But
don't
I'll
need to
just
do
keep
it.
for
You don't need to do
right?
anything because October 1st you automatically change to H1.
Yes.
Okay.
Correct.
Good luck.
Thank you so much, Rajiv.
You're welcome.
Thank you.
Last call, California. California area code 213. Go ahead, please. Area code 213.
Hello, Rajiv, sir.
Hello, sir.
Yeah. I'm an H-1B visa holder with approved I-140. And recently, I founded a company with a partner who is an American citizen.
All right.
Are there any implications for me if I have my company address as my residential address?
I think you guys are better off taking some kind of, or your partner is better off getting a post office or even a shared office space, which is better. Because see, on an H1B, you're on H1B right now or it's still OPT?
I'm on H-1B.
H1B. So on H1B, you can't work for an unapproved employer. So therefore, the closer you get to the work, such as using your office or your home office as the address of the company, I think the more danger there is of USCIS saying, oh, no, this is an unauthorized employment. So I would rather have you stay away from this. Just, getting a virtual office should be only $100, $150, something like that.
Okay. Because the way we have done is I'm a silent partner with 50-50.
Yeah, because that silence breaks if you are
if
you are using your office space and all that. I don't think that's a good idea.
Understood. Okay. Makes sense. So is it okay if we shift the company registered address, because I'm in Washington and company is registered in Washington, whereas my partner is in California?
Yeah, there are companies that can act as what do they call them? Registered agents, corporate registered agents. You can actually Google them.
Yes.
There's one company I remember they used to do a good job. CT Corporation, Charlie Tom Corporation. I'm pretty sure they're still around, and they act as registered agents as well as doing corporate work in all 50 states. Okay.
Yeah. So on that, just a follow up. Rajiv, sorry.
By the way, you can also qualify the company to do business in any state. So, but it's better that you talk to corporate lawyers, because I'm just giving you a very generic statement. I don't know what the laws are. I haven't dealt in corporate law for a long time. Okay.
Okay, makes sense, Rajiv. Yeah, I think I'll make an appointment separately with you.
I can't answer questions about corporate law, but if you have any immigration related questions, I'll be happy to address them for you.
Yeah, it's mostly on the immigration, the implications for me.
No problem.
Yeah, I'll do it.
Sounds good.
Yeah, thank you so much.
You're welcome. Good luck. Okay, folks, that pretty much it. That wraps it up for us today. I'll see you next Thursday on LinkedIn. Thank you all for coming. Take care and the best of luck to you all. Bye-bye.